My favourite case is Quistclose, Barclays Bank and Quistclose, 1968, House of Lords. It is perhaps better known as that awful case I never understood as an undergraduate. It is part of trust law, and it is, I think, fascinating for the following reasons. I should also say, Quistclose for me marks my own identity as a commercial barrister who does financial services, but who is still an equity lawyer, still a trusts lawyer, still a chancery lawyer. And that for me, the coming of Quistclose really marks that point where equity stopped being something that Dickens pastiches as a dusty part of the past to do with wills and trusts and quills and everything that he characterizes equity as. And equity really found its place in the modern commercial world of value in complex commercial and financial services transactions, and equity really started to modernize. It's important, I'm going to briefly just to explain what I think equity is. In the beginning serviceable law in England, you get the rise of the common law courts, and they mete out pretty serviceable, pretty straightforward justice. I've got Buller's Nice Price downstairs, and they are serviceable courts. They're helping the economy along. They're making sure merchants can honour contracts. They're getting things done. But very quickly, the nobility say, no, we would rather raise complex legal arguments. And the reason that they want to raise complex legal arguments is to reverse the outcome. That's why equity is important. If equity didn't reverse the outcome of the common law courts, equity would just be of academic interest. That's why I think it's important that equity is still alive and breathing today and in use and operation in the high courts today regarding complex commercial disputes and financial services disputes. So as we move forward, people were uncomfortable with equity. Equity makes people uncomfortable because it reverses the decision that the common law would come to. That's fundamentally both its strength and why it makes people uncomfortable. So the 19th century solution of dealing with that was to tie equity up in all sorts of complicated rules. And those really come to the fore in Quistclose, because in Quistclose we know what we want to do. The facts of Quistclose are pretty simple. A company is going to go insolvent probably, but it might not if a lender lends the company money. So the lender takes the risk and says, okay, but if you go insolvent, or if you look like you're going insolvent, I want the money back. You know, I know about this risk. I'm not a fool, but you know, I'll try. And inevitably, the company does go insolvent, and the bank and the creditors say this money is ours because you gave it to them. And the lender says, no, that can't be right. And everybody agrees that there must be some mechanism for getting the money back to the lender. There is then huge disagreement on how that is done. The leading judgment is given by Lord Wilberforce. Lord Wilberforce says, as we all know, all property has two parts. It has a legal interest and a beneficial interest. And Lord Wilberforce says, well, what happens, and the reason why the money can go back to the lender is because the beneficial interest stays with the lender up until the purpose of the loan is fulfilled. And because the purpose of the loan was never fulfilled, because the company went insolvent, the legal interest pings back. And it's been characterized as a resulting trust. It's a two-stage trust. It has problems, it has inherent problems, because those rules that we made, particularly in the 19th century, to constrain equity, the ones that, there are very important ones around the creation of express trusts. They're known as the three certainties, that a trust must have certainty of intention, certainty of subject, and certainty of object. And there is an issue with certainty of object on Lord Wilberforce's analysis. Pretty quickly, therefore, the genius that was then Peter Millett QC writes an article in the LQR criticizing this analysis and giving an alternative one. And 20 years later, as he then is Lord Millet, he gets to sit on Twin Sector and Yardley and deal with this issue again. And it's Lord Millet who, unsurprisingly, maintains his position of 20 years earlier and gives a different analysis for why the property moves. But nobody's changing the fundamental truth that we're still getting the outcome that we want. What we're arguing over is the rules that constrain equity or our understanding of equity. And this is what equity lawyers do a lot. I do it all of the time, and because it's fun, and this is why equity law is fascinating. But it has real world outcomes, and the real world outcomes matter. That leads me to the third case. I mean, that argument and that discussion, there's a fight between Lord Millet and Lord Hoffman, perhaps two legal geniuses of the 20th century. Lord Millet is, I think, right, but Lord Hoffman wins the battle of persuading the other law lords, and so Lord Hoffman is the leading argument in Twin Sector and Yardley for why the property moves, which is then important to those of us who have knock-on instances where we might want to do this. And I have dealt, I've been lucky enough to deal already with potential Quistclose issues regarding circumstances I can't talk about in a jurisdiction I can't talk about, because that's all the fun of commercial law. But these are live issues. They really do apply, particularly in financial services. That's where you get the cutting edge. My take on the analysis that Lord Millet is right and Lord Hoffman is wrong, there's then a third possibility that could be me being purely a partisan, and it may be that analysis has been overtaken itself, because to my mind, we are shifting. There is a great modern shift in the 21st century away from the 19th century idea of constraining equity by way of rules and really freeing equity up by way of intention. A lot of this work is done by Baroness Hale and by the family division, because that's where the tension is, certainly in the beginning of the 21st century, to push the law on constructive trust into the area of intention. We get the common intention constructive trust. And what matters and what we're tracking is intention. And actually, when you use that analysis on both Twin Sector and Quistclose, I think you do, it is a very satisfactory one. It's led to the fascinating case of Petrodel and Prest, which ordinarily wouldn't be fascinating to us because it's a family law case and we wouldn't necessarily take a legal interest in it. But in the Supreme Court, knowing the outcome that they wanted to reach, but not knowing how they were going to get there, you get Lord Sumption groping for a solution and stumbling upon the resulting trust and using a resulting trust analysis for why the outcome should be the desired outcome. Total absence, I think really important to notice, total absence of any analysis of the rules or the painstaking application of why we're doing what we're doing. If you compare Lord Sumption with Lord Wilberforce in Quistclose, the difference could not be more stark. They're almost like two different approaches to legal analysis. And that's, I mean, that whether we like that or not on an academic basis, those of us who practice have to follow the modern world is more the Sumption-based world. And the world of intention is going to be much more important. But for me, my favorite case will always be Quistclose, because I'll be able to talk about it and can think about it until I die. I'll always be able to change my mind on the analysis because it's incredibly complex. If Lord Millet and Lord Hoffman couldn't agree, then where does that leave the rest of us? But going forward, the most important, I think, message is that the growing importance of intention and the willingness of the courts to use equity, the willingness to free equity from her chains, these 19th century chains, and to use equity in cases to get different outcomes, to reverse the outcome that would have originally been what we all thought the outcome would be. Now, that is fundamentally both terrifying and fascinating. It's why legal practice is both terrifying and fascinating. It's why I can be both a commercial financial services lawyer and still an equity lawyer,
because it brings the unity in my practice, and I will always be thankful for Quistclose for doing that.